Hello. Matthew sir, can we start?
Yeah, sure.
Yeah. Good evening, all. We welcome you in the expert session on startups intellectual property protection by VC Matthew sir. So VC Matthew sir is handling the intellectual property division in Fox Mondal, which is a 125 years law firm. So Matthew sir comes with a rich experience of handling various aspects of intellectual property rights, including trademarks, copyrights, and designs, while handholding organizations through the maze of clearance searches to registrations and enforcement. He has a legal expertise and action-oriented outlook in IP law firm to constructively collaborate and engage with a wide range of clients from startups to MNCs across diverse industries such as fashion, technology, sports, telecom, and retail. His sophisticated legal prose also supports the clients through the complexities of portfolio management, assignments, and licenses that empower them to optimize, protect, and monetize their IP effectively. He's also a regular speaker with the organizations such as CPAM, FICCI, etc., and has served as an adjunct professor of IP at his alma mater. With a passion for sports and technology, Matthew can be seen dabbing in the convergence of sports and technology law with IP. He holds an education of LLB from Symbiosis Law School, LLM in Intellectual Property from Queen Mary University of London. His affiliations are INTA, Roundtable India, Young Indians. He also holds recognition from Design Subcommittee of INTA, Copyright Committee, a member of the INTA Trademark Office Practice Committee, and also a member of Non-Traditional Trademark Committee of INTA. He also published various newsletters related to IP. He also was a speaker of a lot of webinars and conferences related to IP. So his practice areas are copyrights, design, and trademarks. And he's handling automotive, consumer products and retail, education, healthcare and life sciences, food and beverages, information technology, startups and textile, apparels and accessory sectors. Thank you, sir, for your.
Thank you so much. That's quite a lot that you said about me. I hope I can do justice to it. Firstly, Anupreet, Saqib, Karishma, can you hear me? Firstly, if so, can you just kind of say yes or no onto that, please, onto the chat box so that I know that you can hear me very clearly, because I think some people are facing some difficulties. Yes, great. Thank you, Vedant. Okay, wonderful. So now that we have taken care of the technical difficulties out of the way, I'm going to put up a slideshow. Okay, I think the questions are after the session. Am I correct?
Yes, sir.
Okay, perfect. So we'll take questions after the session. Okay, we'll start off with the session. We'll try to keep it as brief as possible because it's evening. So it's good to see quite a lot of you already here. We expect more later on. And we'll take it from there, and we'll spend quite a bit of time on questions. So as I speak, you can either note your questions down, or maybe you can put it in the chat box. It's completely up to you. And then you can maybe ask it, or the moderator can ask it. Okay, either ways. Okay, let's start. Okay, so I'm going to just share my screen firstly, so that you can see this short presentation that I've put up. Right. Okay, now this presentation should be up on your screens. And as it's coming up on your screens, you will see that there is two words that I've put up there called intellectual property. The concept of intellectual property is not something which is new. It is just something which has gained prominence now. That's the difference. So that's something that you need to understand. It's been there from time immemorial. Now, why am I saying that? Well, let's go back many centuries ago. Okay, let's go back to the time of the Greeks and the Romans. If you look at the Greeks and the Roman time period, you will see that a lot of the trademarks were there even at that particular point of time. What used to happen was people who were there in the trade used to stamp their goods with their particular insignia or logo, thus showing that the goods originated from that particular entity or that particular person, thus denoting origin, which is one of the fundamental requirements of a trademark today. That's a trademark. But I'm talking about a larger concept of intellectual property as such. Now, intellectual property has also undergone a sea change of what it means, right? We have, maybe in our great grandfather's time, talked about the concept of property. Property at that time was, land, land, houses, cars, and such kind of things. And this concept changed over time. What happened was that anything created out of the intellect of one's mind started to be regarded as intellectual property. Now, stating that, why was it important to protect? I mean, it's important to protect your car. We know why that is important. That's an asset, right? Intellectual property, anything created or the intellect of one's mind, started to be regarded as assets as well. It was stated that if a person was not able to protect, or rather some form of protection was not given to that particular person, that person would not have the urge to create again. He would not want to create again. He would have feelings of anger, disappointment. These are things which would come around if a person did not or was not given protection for something created out of his intellect. Therefore, governments came together and they said, okay, we need to protect this, and therefore intellectual property came about. Now, when we say intellectual property, we also need to understand that there are different types of intellectual property, right? So there are inventions, literary works, artistic works, brand names, designs, symbols, names, sound, music, paintings, video, photographs, trade secrets. These are all subsets of what we widely term as intellectual property. So it's quite a unique terminology which encompasses quite a lot of things. Okay, so it's something created out of mind, as we already touched upon. Now, there are a couple of things that I've included here which may beg the question, why have I included sound? Is that a trade? Is that a intellectual property today? Can it be regarded as intellectual property? This must be a question that some of you may be asking. If there are startup founders here today, you may be asking, how should I protect it? How can I protect it? We'll come to that as well towards the later end of our slides. Now, when I give you a right, I give you a monopoly right. And I'm giving you a monopoly right. I'm saying that, listen, you are the right holder and you can stop others from exercising or infringing upon your particular right. So how do I protect it? It is protected by certain IP legislations, right? Now, IP legislations are not there all across the world. They are territorial in nature. There are a couple of applications. So like, if you have the patents, you have the Patent Cooperation Treaty, you have the Madrid Agreement of Annual Protocol for trademarks, wherein which you can obtain a protection, or rather you can file a single application encompassing X number of countries, which give you protection in so and so countries, but it saves you a lot of filing fee. But subsequently, there are objections and other office actions. Those would be governed by that particular law of that particular country. So it's a cost-saving exercise, but it is there nevertheless. It wasn't there many years ago, maybe 10 years ago, it wasn't there, but it has come into being. Therefore, that is something that you need to know, that there is something like this. Earlier, what we had to do was to protect your rights because, like I stated, they're territorial in nature. You had to go to the respective jurisdictions, whether that be United Kingdom or the United States or Africa or wherever, to get your rights protected in each of those countries, which proved to be a very, very, very expensive exercise. Imagine if I was a big multinational corporation, I had interests in 60 countries in the world, and I'm filing 60 trademarks and then 60 copyrights. Subsequently, the amount of money that I would have to expend is enormous. Therefore, these agreements are there to ensure that you can bring your costs down to a large extent. Now, the types of intellectual property. I mean, I touched upon a brief number of things. The best way to understand the types of intellectual property is to just take the mobile phone in front of you. I would have usually done this exercise if you were there in person. We would have taken the phones and we would have, asked you a couple of questions regarding it. But since that is not available today, let's do this in a slightly different manner. Could everybody just look at your mobile phones, which is there on your desks or on your pockets? You will see a couple of things on your phones. So I've used the word Nokia here, or used Nokia phone rather. If you look at the word Nokia and the symbol, those are trademarks. Maybe a couple of you may have a Samsung phone, which is only a Samsung word written on it. A couple of you may have the Apple phone, which has got an Apple logo on it. Therefore, a logo, a name, these are all trademarks. Now, when you come to your copyrights, so that's the two subject matters that we are going to touch upon. you will see that a mobile phone also encompasses quite a lot of copyrights. And how is that possible? The software on your phone, it could be the iOS software of Apple, or it could be the Android software, which is available on most of the phones today, or a fork of the Android software, which is also there, like on OnePlus phones and other certain other models. There is a fork of the Android open source software, which is there. So that is a copyright. Software is a copyright, but understand that software can also be regarded as a patent. It would depend on whether it's been filed along with a physical a piece, like if it's filed along with the phone, then yes. If not, standing by itself, software is copyrightable. This is just for your understanding, because it falls into categories and sometimes you could get confused as to where it does fall. User manuals, which could be there, which would be considered as literary works. Ringtones, music, something that we all like to hear, something that we heard a lot of during the pandemic. Those fall under copyrights. The startup tone obviously is copyrights, and images on your phone are also subject matter of copyright. Photographs taken on your phone by you are copyrightable, so they are subject matter of copyright again. The logos on your phone for various applications, they can fall in two categories, both on trademarks as well as on the copyright category as an artistic work. So there are multiple protections which can be got for certain things, depending on what the subject matter is at the end of the day. Over and above this, there is also patterns and there is designs as well that you can see on your phone. The shape of your phone is a design, and the data processing, the operating system, the UI, all these are also patentable subject matters. I won't go into too much detail there because that's not the subject matter of study today. You also have trade secrets and geographical indications. Trade secrets are, best example I can give you is of the Coke formula. That's a trade secret which has been protected for quite a few years now, and nobody knows what or how the formula of Coke is. If you try to replicate it, you may not get the exact taste of Coke. So that's a trade secret which is locked up. As far as a trade secret is concerned, one does not expressly need to file for it, because if you file for it, then it will no longer be a secret, right? So if you and me are sharing a secret, we would just keep it between ourselves. We would not let a third party know about it. That's a secret. Similarly, trade secrets are best left not filed for and best left locked up in a safe somewhere, like the Coke formula. Okay, the first subject matter of study today is trademarks. Now, trademark, as the word suggests, it's a mark which denotes something in trade. Okay, it's a logo, a word, a slogan, a sound, a three-dimensional mark. Earlier, you only have logos, words which are considered as trademarks. That was a simple way of understanding what a trademark was. But over time, slogans, sounds, and three-dimensional marks also came about. Now, why is this? I'll come to that. When I said trademark, it denotes trade, right? It denotes that when I see that logo on a phone or a shoe, I know that I can, safely take it. I can purchase it. There is no doubts in my mind as to if I should purchase it. The only doubt is whether I should pay so much for it or not, right? But I'm still willing to pay for it. If you look at launches of the Apple phones today, or even certain Android phones, Samsung phones, there are people who queue up to pay $1 lakh plus to buy a phone. Can you imagine $1 lakh plus to buy a simple phone? That is a ludicrous amount of money, but people are willing to pay for the brand. The brand is what matters a lot. People are willing to pay for it because there's a reputation and a goodwill attached to it. And that reputation and goodwill also denotes the origin of that brand. Case in point, let's say there were two phones put side by side in front of each of you. One phone with the logo on it, one phone with the name on it, and the other phone with nothing on it, no indication whatsoever, the specs being exactly identical. 99% of the time, all of us would choose the one with the logo and the name on it. That is because we, as human beings, have that faith that, that brand has a value attached to it. There is a certain sense of quality, certain assurance that we feel when we pick that particular brand. And that's the same for pretty much everything, our shirts, our phones, our laptops, our mouses, anything that is there today that we have in our possession, our cars, they are all based on a particular brand. And we are pretty much slaves to this at the end of the day, So that is why building a brand is important. And it is not only building it, protecting it as well. It might not mean a lot to a lot of us, but to the person who has created that brand, who's put in his life savings, who's put in his sweat and blood, that means a lot, and he will go to any lengths to protect it. Coming back to slogans, sound, and three-dimensional marks. Logos and words, we are easily identifiable as trademarks because it denotes origin, right? After a while, slogans started to denote origin. If you go back in time and look at the Pepsi slogan of Ye Dil Mange More, you will understand that a slogan can be regarded as a trademark. Nike's Just Do It is another iconic slogan, which is regarded as a trademark today. Then you have sound and three-dimensional marks. Now, all of these could roughly be categorized as non-traditional trademarks because traditionally they were not recognized as trademarks, but they have come to be recognized as trademarks over time. So law keeps changing. It is always in a change of flux. It has to keep up with the times. Therefore, you could state that, as law changed, what were earlier not regarded as trademarks came to be regarded as trademarks today. So if you look at the movies that we've all watched during the pandemic on OTT service providers, there is a sound which comes every time an MGM movie or a movie produced by MGM Production House comes on the screen, and that's of a lion roaring. So every time we hear a lion roaring, we regard it as a production of MGM. So that's one of the iconic sound marks which are there. The first sound mark in India was obviously the one known as the Yahoo Yodel. For those who remember Yahoo, which was a major tech company of yesteryears, it had a unique sound, which I'm not going to depict right now because that would be pretty funny, which used to come. So you can check that on the internet. You can just do a search on Google and see what comes up. You would find that there is this very unique sound which people regarded, and that was the first sound mark of its kind in India. Then you have three-dimensional marks, the shape of a bottle. There are various alcohol companies or alcohol bev companies who have unique shapes. These shapes could be both subject matter of designs as well as subject matter of trademarks. So certain shapes, just by the shape of it, can be regarded as a trademark. Take the iconic Toblerone chocolate. The unique shape of the Toblerone chocolate is so unique that they don't have to write Toblerone on it. Just by seeing it, a consumer would regard it as a Toblerone chocolate. Color is another example of a non-traditional trademark, which I have not put here. The purple color for chocolates, Cadbury's, or maybe the red and white color scheme for toothpaste, Colgate. In India, just keep in mind that a single color cannot be regarded as a trademark. It has to be a multiple set of colors. You cannot have a single color trademark. You don't have multiple colors. Okay. So these are roughly what are regarded as trademarks. There are obviously changes which are always occurring. There is a huge debate going on whether smell should be regarded as trademark. Outside India, they are trying to, or there is a case wherein somebody had filed for a tennis ball which smelled like freshly cut grass, and they wanted to file that as a trademark. So it was rejected in the European Union. So there are, they're stretching the concept of what is a trademark a lot nowadays. So over time, maybe these will also be regarded as trademarks. You never know. The important fact to understand that in India, as per our Trademark Act, if a trademark is to be registered, it has to be graphically represented. So if it cannot be graphically represented, it cannot be regarded as a trademark. A mark can be used or proposed to be used. There is a simple funda behind this. India is the first to use country rather than the first to file country. So you as a startup owner may have been using your trademark over the last, let's say, 5 years. You may not have filed your trademark at that particular point of time. No problem. At the time of filing, you may claim a date of use 5 years prior, as long as you have evidence to substantiate it, which have to be filed along with an affidavit at the time of filing. So you can claim the date of use. So your protection starts from that particular date, not from the date on which you're filing your application. This is useful. Why? It is useful when you're trying to enforce your rights against another entity who may have started using it subsequent to your use, but maybe prior to your date of application today. So you could enforce your rights, and this is something the concept of prior user has been recognized by courts in multiple cases wherein right holders have tried to enforce their rights against another entity. So this is important to understand and to note that India is the first to use country. The United States, not so. Civil law is the first to file country, just for information's sake. Okay, a trademark is valid for perpetuity. Now, somebody is going to ask you why it has to be, well, how can it be valid for so long? It is valid for so long because I'm giving you a monopoly right. I believe that it's a right which you own, which can be extended for your lifetime, your heir's lifetime, your company's lifetime, and so on and so forth. The only condition that needs to be met is that every 10 years, you need to file a request for renewal. Prior to the amendment rules in 2017, the renewal used to happen 6 months prior to the renewal date. But after 2017, when there was an amendment to the practice, you could file, or rather, you can now file an application to renew your mark 1 year prior to the renewal deadline. So when you get your registration, just keep in mind, or you have these very nifty calendar apps. So put in your renewal date 10 years from now, and a date to renew your mark 1 year from that particular renewal date as well into your calendar, and you will never forget it. Even if your agent doesn't inform you or your attorney doesn't inform you, please make sure that you get your mark renewed, because if you do not get your mark renewed, it will be subsequently abandoned, or it will lapse, and therefore your rights, though your rights will still be there because we recognize prior user. But as far as statutory rights are concerned under the Trademarks Act, those will not be available to you to avail of. You would go back to common law, which you'll have to use to enforce your rights against another entity. Trademark infringement, just for your knowledge, is only available to a person who's got his mark registered. Subsequent to filing, or even prior to subsequent to registration, or even prior to your registration, you could file an assignment, you could change your name, you could change your address. All of these things can be done. There are requests which can be filed for each of these. If there has been such kind of change, maybe you file it in your name and then you want the company to now own the rights in it, you can have it assigned to the company. There's a whole host of things which you can do, depending on what your structure is, depending on what kind of monetization you want to do. You can look at these recorders and requests which are can be availed of, but do avail of them, because you need to keep the records of the trademark registry up to date. This is particularly important if you are enforcing your rights against another party, because you want everything to be updated and on record. Okay, so the importance of a trademark, one, it protects origin. Imagine if I didn't know where the goods came from, I would be apprehensive in purchasing them. You would be apprehensive in purchasing them. Go back to the example of the phones. We would pick the phone with a brand on it. Why? Because we understand, yes, this comes from Samsung, or yes, this is an Apple product. I have complete faith that it is a product of quality. It's a product one which it will sustain the the wear and tear that my phone is going to go through, and therefore I purchase it. The other phone might have the exact same specs, but I don't know where it came from. Therefore, if I do not know where it came from, I am going to be slightly apprehensive as to whether I should take it or not. My mind is going to go 50-50. Should I take it? Yes, the cost is less, but I don't know where it's coming from. So these are the things that are going to go through my mind, and my mind is exactly like yours when I'm looking at such kind of a purchase. And this is the same for everything we purchase today in today's world. We take services of brands that we know of. We buy goods of brands that we know. We place our faith in them. Sometimes even the quality of a product which may not be known might be higher, but we nevertheless believe that the brand gives us quality, and therefore we are going to go with it. And to a large extent, that is true. Brands do give quality. Yes, there is a certain quality, there's a certain reputation, there's a certain goodwill attached to it. And that's my second point, reputation and goodwill. This is also very, very important. As a startup, when you start your entrepreneurial journey, you come out with a name, you come out with an innovative product, you give that product a name, and then you put it out in the market, and then you try to monetize it. Over time, years later, over marketing and social media and other mediums, you develop a reputation and a goodwill attached to that particular product. By hearing the name of the product, the consumer says, that's it, I'm willing to pay X amount of money to purchase a product. That's the reputation and goodwill that you've garnered over years of work, hard, sweat, toil, and tears that you've put into your product. Now you want to protect it. If it is not protected, what would happen is that there will be substandard products which would come out in the market, which would dilute the reputation and goodwill which you have accrued over time. And it has been a painful exercise to accrue it. It's not been easy. Therefore, you as a monopoly right holder would like to protect, and you will protect your rights against another entity. Hence, you do not want another entity with an identical mark or an identical or deceptively similar mark to be there in the market, which could confuse consumers. And that is why you protect your reputation and goodwill. And it is very important to protect it, because in today's world, that is what is selling: reputation and goodwill. It is very, very, very important. With social media being out there, it is a double-edged sword. Yes, it helps us in marketing, it helps us in connecting, it helps all of you as startups, to give you a good platform to be able to market your products, to be able to be in touch with your consumers. But it also acts as a forum wherein a person, a consumer, may put forth his grievance regarding the quality of your product, regarding the quality of your service. Therefore, you as startup owners and entrepreneurs need to be very, very careful as to what is there on social media. I've seen a lot of companies take the efforts to respond to every single person. Sometimes those kind of responses, even if the negative response, they actually respond to them, and then they take extra efforts to call them up. This is something that all of you do. And you might get a lot of goodwill out of that kind of an exercise as well. So be very, very careful what is out there. Protect your reputation, protect your goodwill attached to your brand, because it is very, very important. Therefore, just filing for your trademark is not important. Enforcement is equally important. When we come to good practices, I will touch upon certain things that you as startup owners need to do, some things that we have faced with startups when we have worked with them, and some things that we guide people on, certainly. So we'll come across those as well. Monopoly rights. Again, yes, trademark is a monopoly right. It's what we call a negative right. It's a right wherein you protect, or rather you protect your right against any other person, basically, because you have a monopoly over it. Therefore, you're kind of preventing anyone else also from kind of utilizing your trademark for their goods and services. So it's what we call a negative right. Okay, so this in a nutshell is what trademarks is all about, and its importance for you as startups. This is maybe the easiest thing to understand for a startup, because you all have it. There isn't a single startup that I've come across who hasn't got a trademark or a trade name or a logo. Everybody has it, so be very careful about how you go about creating it. We will touch upon good practices as to how to create it and what you should look at the time of creation as well later on. Okay, moving to the second subject matter today of copyrights. Now, copyright is not the right to copy. Please don't get confused by that terminology. Rather, it's the right not to copy. Okay, it has historically been linked to written literary works. Now, in the early ages, we had books which were there, manuscripts, which took a long time to get written. It was not easy to copy them then. It was practically impossible because it took years to write up something. Maybe entire lifetime of a person to write up a complete book. But something changed in history. If you look, the printing press came about, and with the advent of the printing press, one could create copies of works now. It became very, very easy. Much easier than, writing it, right? Put it in the printing press and create a copy. We have advanced stages of printing presses now. We have the photocopy machine and a whole host of other machines that are out there today, which make it very, very easy for works to get copied. Therefore, once the advent of the printing press came about, there was a requirement amongst the people, the entrepreneurs like you, for protection of these literary works. Now, why was that protection important? The protection is very important because if you look at the type of works that a copyright governs, which is the last point on the slide, you will see that all of them are very creative works. Now, with creative works today, take your cases today. If you are creating something and someone was to steal it, you would be disgruntled, you would be disappointed, you would not be motivated to create another work. You create it the second time saying, okay, put aside my feelings, I create again. Again, the same thing happens, someone copies it. Again, the same feelings would come to the forefront, and you might just decide to quit. You might just say, enough is enough. I'm not going to create again because it's not worth it. What's the point of putting my hard work, my skill, my creativity into, this particular work, and then someone easily steals it? I might as well not create it, right? Imagine a world without music, books, art, video, and audios. Imagine a world such as this, and just think of how bland it would be, how boring it would be, right? There would be no color in the world, literally. That is why the creation of these works is very, very important. And not only is the creation important, we need to protect the creators. And if you're not able to protect the creators, then we as a society will not move forward. And that is how these works came about to be protected under law, and the law which protected them came to be known as copyright law. It is an inherent right. This is something that you need to understand. Now, what do you mean by an inherent right? An inherent right means that the copyright vests from the time of its creation. This basically means that one does not need to expressly file for a copyright to obtain protection. From the time of its creation, its inception, the rights start to accrue. You could then take and enforce your right against another party. And which begs the question, why do you even file it in the first place? The answer to the question is enforcement. You have enforcement actions which take place physically at locations. You have enforcement actions which take place online. And nowadays we have a new kind of online environment coming, which is known as the metaverse. We're still thinking of how to protect our rights there. There are obviously many schools of thought there, which we will not go into maybe in another session, but not today. But there are numerous challenges as to enforcement, and therefore it is essential that you have your rights protected and you have a piece of paper which shows that you are the right holder. Otherwise, there could be a challenge, which would then need to be, proven by virtue of evidence that you are the actual owner of that particular copyright. That's why it's important and paramount to file expressly at the copyright registry, even though copyright is an inherent right. Copyright is also a bundle of various monopoly rights. It's the right to make adaptations, right to reproduce the work, right to issue copies of the work in public, right to make translations, right to communicate that work to the public. In short, it's the right against copy. So I might make a book, but the book could be converted, let's say. So Harry Potter, or J.K. Rowling wrote Harry Potter. Harry Potter was converted to a movie, which was then, it could be adapted to a dramatical work or a play. There could be maybe J.K. Rowling's book could be written in different languages. So these are all various rights which a copyright holder has. He or she can exercise it at any given point of time, or he could have someone else exercise it as well. The author of the work is obviously the owner of the work, but there are instances when this is not so, which I will try to show in the next set of slides. I'm just taking a couple of works. So if you take a photograph, the photographer is the owner of the copyright. If you write a book, the author of the book is the owner of the copyright. If you write music, the composer becomes the owner. Artistic work, obviously the artist, and so on and so forth. There are cases where it is not so. The exceptions are, let's say, the literary work or the artistic work was made in the course of employment. So today, my slides, which you're seeing on your screen, though, yes, I've created them, they don't belong to me. They belong to my employer, Fox Muddle and Associates. They don't belong to me, right? Because I've done it during my employment or my consultancy with them. Photographs which have been commissioned, a lot of photographs are commissioned to be painted for X amount of money. Therefore, the owner who commissioned it becomes the owner, though the author of the work is somebody completely different. Works created for the government, musical works, again, the composers, the previous slide, I think, had a typographical error. It's it should have been the person who wrote it, the lyricist. But in a musical work, you give it to a T-Series, or you give it to Spotify or Apple or whoever your production houses, musical compositions for the music to get produced. So they become the owners of that particular copyright because they're taking the risk. Understand that all of this has come because they're putting in the money, they're putting in the investment, they're taking the risk. Because if it's a success, great, they make money. If it's not a success, then, well, you have a problem wherein the loss has to be borne by them as well. There is a new concept which is coming about called decentralized music. This is also in line with Web 3.0 and so on and so forth. For those who are interested, check out this nifty application called Tita TV. It's something like YouTube, but YouTube's owned by Google, wherein Tita TV is not owned by anyone else. You can pretty much put up material. So composers and musicians are looking to monetize their assets in various ways now directly rather than giving it to someone else. With books, I know there is a lot of self-publishing which takes place because there are a lot of self-publishing entities out there today, and you can basically pretty much publish it yourself. unlike going to a Penguin or any of the other publishing houses that you have to go to get, or rather had to go to get your book published prior. So these are in a crux what copyright encompasses. It's mostly creative works such as literary works, artistic works, musical works, photographs, computer softwares, audio recordings, video recordings, movies, basically. So all of these come under the ambit of copyrights. The exceptions and the owners, that's just for your knowledge to understand. Now, I've already touched upon this just briefly as to what these are and what they encompass. A lot of you as startups may have a lot of copyright. Trust me, actually, you all would. It is just that you don't know about it. Maybe a couple of these things on the slide would maybe set up light bulbs in your head as to the copyright that is vesting with you already. Whether you file for it or do not file for it, that's completely up to you. It is not a mandatory requirement, though it is essential, especially if you're looking to monetize your asset, especially if you're looking to enforce your rights against another party. Please do go and spend that money to protect your copyright. Actually, trademarks and copyrights, do not look at it as expense. Look at it as an investment, which would then make more sense to you. And I'll come to that towards the end of my talk. Okay, a copyright is valid for the life of the author, like 60 years. Again, that's the term. Just like in trademarks, it's valid in perpetuity that we talked about. In copyrights, there is a time where it comes to an end. Now, the question is, why should it come to an end? Why couldn't trademarks also come to an end? Well, simply put, being a creative work, if you look at the ages of any creative work, right? Any creative work is built on top of another creative work which is already there. So creativity requires that there is some material which can be used to create something new. So if I was writing a book, I would be researching on a whole host of articles and analysis and reports by a whole host of people who I would attribute when I write my book. So my book, even though it is have standalone copyright by itself, is also borrowing material from other parties to create it, right? I've read up, I've studied, and I have attributed all that in my book in the footnotes when I have come out with my work. So it is all based on something. That is why after 60 years or after the life of the author, they say that the copyright comes to an end, and then people can take it, comes out in the public domain, people can use it, and people can create more newer works which might be very unique in nature, which is enjoyed by us as a society. So this is in a crux the term of protection which is there for a copyright, which brings us now to the importance of a copyright. One is it encourages creativity. Like we stated, is if I don't protect the work, if I don't protect your work, if I don't offer you some kind of protection, you don't, or your dissolution, don't feel a requirement to create again. To create again, you need some form of protection, and that is what copyright offers. It protects your works, which is very, very important, and it also helps you monetize your works, and it rewards the creator. So mere protection is not required, is not only essential, it is also needed that monetization is required. In today's world, you look at anything which is out there, everything is monetized, right? As startups, you are looking to monetize your product, you're looking to monetize and you're looking to monetize to the best of your efforts. So monetizing your work in today's world is very, very important. Therefore, if you are going to create something, understand that there is maybe going to be a monetary attachment to it. Therefore, monetize your works along with its protection. It also rewards you, the creator. So, and it rewards you, the creator, through various instances. One is through money, and others to feel good about that you attribute as a creator or something, right? Who doesn't? It's human nature to like to be appreciated, and that is something that happens for many, many creators today. Interesting cases of if you take a car, the wiper of a car is 3 speeds. Was created by an individual who basically had a problem with his eye. So the slow and the fast speed does not work for him to make. So he came out with a speed in the middle. Car companies hired him, took his work, and kind of threw him out. But he fought the case and won. And right before the judgment, most of the car companies came and offered him a huge amount of money, which he refused. He asked only one thing in return. He said, "Would you regard me as a creator?" They refused to do that, because by doing that, they are admitting to the guilt of stealing his particular patent. It's a patent, actually, trading is patent, right? But that is the necessity to be regarded as a creator today. So as a startup today, you put in a lot of effort to create something, ensure it's protected. Copyright law is there to ensure that you're able to monetize it and ensure that you're rewarded for the sweat, the work that you've put in to create this particular thing that all of us enjoy today. Now, as a startup, there are obviously good practices which one needs to attribute. Now, this is not written anywhere. There is nothing which says that you have to do this. But this is something that we have seen over time working with startups as to the things that we've seen, the errors which are occurring amongst startup industry. And these are what we're trying to do. And maybe the session is set up to help you as a startup understand what you need to do and how you need to do it before you actually make these errors, which many people in the past have already done. So I have divided it between trademarks and copyrights, so it's much easier for you to understand. Trademarks, make sure your trademarks are distinctive in nature and not descriptive. Descriptive trademarks are not good trademarks. They are not given protection because you cannot have a mark which describes your product or service. You cannot have mangoes for a mango seller. It's impossible. But having Apple for phones is fine because in regard to phones, Apple is a word which might be generic in nature. Yes, an apple is a fruit. But who talks about a fruit for a phone, right? That's ridiculous. So that is why it is a good trademark to have. Do not have a mark which is descriptive because as per Indian law, you would not be in a position to get it registered as well. There are marks which are registered. How that is so? Because they've been using it for a long period of time and then they file it saying that they've been using it for the last 20 years. Therefore, there is nothing being attached to that particular trademark. So this is the only way one could possibly look to file it. And I would not advise you as a startup to do it because as a startup, you're at the stage of creation. Therefore, you can create something which is distinctive, something which is coined, something which is arbitrary in nature. At the end of the day, understand the objective of creating a trademark. Your trademark is created so that I, the consumer, there's a brand recall value in the mind of me, the consumer, right? If there needs to be a brand recall value today, the mark has to be distinctive. Take any of the services that we use today. Google for our search engine, Samsung for our phones, Apple for our phones, Nestle. Okay, Nestle is actually a surname of a particular person, and so is Maggie, but they have gained popularity and secondary meanings over the years as well. But any, or rather most of the trademarks that we are in constant interaction with today are very distinctive. They're mostly coined words. Even Xerox for a photocopy machine. That is also a coined word. Xerox does not mean anything. So MRF, again, it's an acronym for Madras Rubber Factory, but MRF is standing by itself, does not mean anything. So again, so these are all various trademarks which are there, which are created. Adidas is another excellent example of a word which is created. Contrary to public opinion, it's not all day I dream about sports. It rather is actually the combination of the first and the second letter or alphabets of words of the founder's name, Adi Dassler. So ADI comes from Adi and DAS comes from Dassler, thus creation of word Adidas. So that's something for you to think about. In the initial stages, when you go to your lawyer to conduct a trademark availability search, which we would always advise, because you need to understand what is there on the record of the trademarks registry before you can file it. It's no point saying I've come out with a great mark and then being told 6 months later post-filing that I'm sorry, there's an identical mark sitting against you. Therefore, this is not registrable. We will have to let go and we'll start off with something new. By that 6 months, you would have spent a huge amount of money, visiting cards, office signage, advertising, Facebook pages, Instagram posts, and a whole host of other things. A lot of money gone into all of that, all down the drain, right? We don't want that to happen. So conduct a trademark availability search, speak to your lawyer, ask him, listen, I would like to file my trademark, but I have 3 names. I would like you to, this is my, and 3 names, listed as per your importance, as per your requirement, and then search for the first one, see if it is available. If it is not available and there's a huge risk attached to it, then we can go for the second one and then post at the third one. So give him options. Don't be at that stage where you're fixated on one mark. 2 weeks before launch, you tell your lawyer, listen, I would like to do a trademark search. He comes back 3 days later saying, sorry, not possible. You are now 4 days away from launch and then you don't have a name to launch with. Don't put yourself into that position. Plan well, organize it, get everything in place, then fix on your mark. Because some marks which you think might be registrable legally may not. Therefore, it is good practice to be in constant touch with your trademark attorney to be able to filter out what can be regarded as a trademark and what cannot. I'll come to allocation of funds at the end because it's there for both trademarks and copyrights. I'll go on to obtain a startup certificate or an MSME certificate. So as a startup today, there is an option under the government scheme to obtain a startup certificate if you meet the prerequisite conditions. It's a simple process. You can go to the Startup India website and take a look at it. It's not a very complicated process at all. But the obtaining of that certificate is important because it gives you a reduction in the official government fee for filing a trademark. So if you were a normal company, you would pay 9,000 rupees. Whereas if you have a startup certificate or an MSME certificate, your cost would be 4,500, which is a 50% reduction or 50% rebate, which the government gives you. This was done by the government to encourage startups to file their trademarks. This was not there earlier. So this is under the startup scheme, which is there for you to avail of, to avail it. But understand that it can be availed only with the startup certificate, which has to be provided at the time of filing your trademark application. And seek the broadest scope of protection possible. A lot of people do not do this. Simple reason being that costs come into play. 4,500 rupees is the official fee per class. This is the government fee. I'm not going to go into the professional fee because the professional fee varies firm to firm, lawyer to lawyer, it varies. So I'm not going to go into that. But the official fee is 4,500 rupees per class. Now, what one can do is that the lawyer would suggest the broader scope of protection, which might be more than one class. So to give you an example, you may be a manufacturer of clothing, but you may be manufacturing and selling as well, right? That's a natural corollary. So your manufacturing falls in one class and your sale falls, the retail and wholesale sales fall in another class completely. So that is two classes which need to be covered, which is basically your business. The lawyer would put forth saying it's 4,000 rupees, 500 rupees plus 4,000 and 9,000 rupees. You would say, I can say 4,500 rupees, so let me take care of it. One class is more than enough. So you are limiting your protection, which could be disadvantageous to you in the future. Please understand that intellectual property rights is what most of your business is all about. Okay. Today, brands are bought and sold only on the reputation, technological know-how, and goodwill. Nobody wants land, nobody wants factory, nobody wants anything else. They're able, not even labor, not even people are required. They're able to hire their own people, they're able to have their own land, they're able to have their own factory. What is required is the brand, the reputation, the goodwill, and sometimes even the technological know-how which you have in your startup. That is what they're after when they merge, when they're purchasing you. This is what they're after. They're not after you or anything else. So please keep that in mind. Therefore, this cost is, like I said, not an expense, but an investment. Okay. When it comes to copyrights, file a copyright at the Copyright Office. I know it's an inherent right. I've already stated that. But file it nevertheless, because it's important for your enforcement. Enforcement of rights is as equally important as filing for it. If there is a coin, filing is one side of the coin and enforcement is the other side of the coin. Therefore, both these sides are equally important for you, the owner of that particular startup, because without enforcement, your brand gets diluted. This is what happens many a time. In China, once upon a time, the Zippo lighter had so many infringements that one could not understand if they were purchasing an actual, the original lighter or a fake Zippo. Zippo had to spend huge amounts of money over numerous years to try to bring down the number of counterfeits in the market because it was affecting its brand, it was affecting its goodwill, it was affecting its reputation. So this is the amount of money one would have to spend if he or she does not enforce his rights on a regular basis. Okay, do not allow your brand to get diluted, because if you do allow it to get diluted, you would not be able to enforce it strongly as well. Obtain an NOC from the author of the work is commissioned. So a lot of you may have created an artistic logo. You may have bought your advertising agency to create it. immediately get an NOC from that party, because you may want to, and not from the advertising agency, actually from the person who created in the advertising agency, because under copyright law, if you want to file your logo as a copyright, you need this NOC. Many a time you've seen, when we ask for an NOC, they say, oh, we don't know who created it. When they say, yeah, we know who created that ad agency, they go to the ad agency, but the person who used to work there no longer works there. He was the guy who created, now he's gone. He's left the employment. Now imagine your plight. You cannot file your copyright, which is rightfully yours, just because you can't get this NOC. So if you're giving it out to an ad agency or somebody to do it, to create it, no problem. Please do so. We are not all creative by nature. God has not blessed us with all the skills possible on earth. But if you're going to do it, please get that NOC from the person at that ad agency who created. Make sure this is in your to-do list, that yes, payment made, before payment made, NOC got, keep it in your records, scan it, keep it in your cloud storage, have a file for it, put it in it, keep it there safe. Because if somewhere down the line you look to file your copyright, you will be asked for this, but at that particular point in time, you will have it ready to be able to present it. And the last point here is the allocation of funds which are there for trademarks and copyrights. Often we have come across startups who don't go in for the broader scope of protection, who don't go in for a trademark search, who don't do many things. Only reason being that they are not allocated the funds properly. They many a time don't even enforce their rights. We find it strange, because 4 years later they come and say, yeah, humko ye action karna hai, let's do this. But it's not possible, because your brand is diluted. There are 100 people in the market today. It's not possible to do it. Like, there are also restrictions as to what a lawyer can do. We're not magicians. We can't pull rabbits out of a hat as in when a startup requires us to. What we advise is, and this is very, very good advice to look into. You have allocation of funds to computers, to your employees, to the rent which has to go for your premises, and so on and so forth. So many different heads, right? Have one more head, legal expenses. Allocate 10,000 rupees to it, 15,000 rupees to you, whatever you feel like, but allocate it nevertheless. Maybe it does not get utilized in the month of July. Maybe it does not get utilized in the month of August. So let's say I allocate 10,000 rupees. July I have not utilized, August I have not utilized, September I have not utilized, but now my kitty stands not at 10,000, it stands at 30,000. In September, I want to enforce my right against somebody else who's trying to, file a trademark and publish in the journal. I file an opposition against it. My lawyer informs you there is this person who's trying to infringe your trademark. Do you want to take action? Yes. Why? Because I have money sitting there which I can utilize for it. At that particular point of time in September, I am not thinking, oh, it's going to cost me so much. Should I file it? Should I not file it? Maybe I don't file it. I can save this 10,000 or 15,000 rupees. Then I can send it to, buy new coffee machines for myself or whatnot. I'm not thinking like this at that particular stage. I am thinking, I have the money and this guy is trying to infringe my mark and dilute it. I will not allow him to do it because it affects my brand directly. I'm going to take action. And there's no two ways. I'm not thinking twice about it. Therefore, this kind of planning of funds is very, very important for each and every startup today. It is something that we believe is maybe lacking in India today to a large extent. I mean, we have seen huge number of startups come. We've seen a whole host of services, whole host of you coming out, entrepreneurs coming out. But we also need to learn how to do the business as well. And having your lawyers in tow, working with them in partnership is very, very important as well. Therefore, do look into this because it is very, very essential. This is maybe one of the biggest mistakes that a lot of startups do. And therefore, my advice to you tonight is don't make that same mistake. Allocate the funds, keep it there. Do not utilize it for anything else. Keep it there. Let it accrue over time if it has to accrue. Put it on an RD if you want to. Get interest on it. Do whatever. But do not utilize it. Do not take away the opportunity to enforce your rights. Please understand in the end that this is all, a story, your growth story, your rights, your brand, your reputation, your goodwill. It is not important just to file for it. It is also important to enforce it. They are both two sides of the same coin. It is encouraging to see all of you come out there and, take a foot forward and do and start your entrepreneurial journey. Now, protect what is the most important thing in that entrepreneurial journey by going in for your IP protection at the earliest. And when I say at the earliest, when you start off at the starting stages itself. One more point in respect to fee is basically this. There is also known as something known as a startup facilitation scheme, which is again by the government of India. As per the startup facilitation scheme, there are a lot of facilitators which are there online. If you're going as per that particular scheme, you don't even need to pay professional fees. You only need to pay official fees. But the only problem or only lacunae that we have seen in that is that you don't know who you're approaching. So therefore, a lot of startups get tied up with people they don't know of, people who may not have the quality to service them properly. And therefore, at the end, a lot of mistakes are made. Therefore, so I mean, it's completely up to you. The idea is a grand one. The idea is a very noble one and a very good one by the government. The execution of it has its cons as well. And one of the cons is you not knowing who you're interacting with, you're not knowing what the quality of the service being offered to you is. Services obviously cost money, just like you are charging, services also charge. So don't be scared to spend that money. Think of it as an investment and not an expense. So on that note, I'll stop talking and I'll open the floor now up for questions or however the organizers want to do it. Yeah.
Thank you so much, sir, for the wonderful session. So, sir, can we start Q&A now?
Yes, yes. Perfectly. Please, please.
Yes, sir. So participants, you can ask questions on the chat box as well as directly by unmuting yourself to sir. So there is a question on the chat box. I have already filed application for trademark, but there is an objection. Please suggest what to do.
I'm sorry, I was on mute, my bad. So can the person who's asked that particular question just unmute themselves and ask me, because there are a couple of questions that I need to ask to be able to answer the question. Firstly, I can't tell you, I don't know what objections you're facing. So all I can tell you is that if the objections are faced, if it's an objection or an opposition, then you're facing it at the examination stage. And if it is faced at the examination stage, you need to file a response. A response should have been filed within 30 days or more a month of the receipt of the objection by virtue of the examination report. So unless I see the objections, I will not be in a position to tell you how to respond to it or what one should respond to it. I can, just a minute, I can maybe leave you my email ID to the person who's asked. If you want to get in touch, yeah, you can. Okay, great. So if the person is there here today right now, please unmute yourself and ask me, then I can answer your question immediately. I can give you a rough idea. Actually, I may not be able to go into too much details unless I see the particular objections, but I can give you a rough idea.
There is the other question on the chat box also. Is idea directly made be a trademark?
I don't understand what this question is. Basically, Evith, are you there? Is she here? Okay. An idea cannot. So you could. You can't protect an idea. There has to be some form of. It has to make itself into some particular form for you to be able to protect it as a trademark. So if I have an idea of starting a business selling paint, and I create a logo for it, then yes, I can protect the logo. But the idea of a paint company is not something I can protect. It's basically a trademark is something which needs to be graphically represented, and it needs to be tangible in the sense that I need to be able to see it, right, to be able to protect it. Okay, I don't know where E with this. Wait, okay, there's another question from Unnikrishnan. If two startups are co-owners of a granted patent and it's only one startup which makes and sells product with respect to the patent, what can the other startup do? Well, it would completely depend on what your agreement is. When you entered into a co-ownership, what were the terms of the agreement between both of you? Was it that there was a share of revenue or licensing fee that both of you had, Unnikrishnan? Because that would finally determine as to what you're going to get in respect of that particular patent. It's completely dependent on your agreement. So unless rather just therefore the answer to your question is look into the agreement that was made between both parties at the time of when they got into business together. If there's no special agreement where the company undivided share and the maintenance fee is also shared equally, well, then you'll have to speak, both of you will have to speak to each other, right? Because so the first thing is your first mistake is there's no agreement. You have taken over and or rather you filed for an asset, and now you have a confusion or a fight over the asset, and there's no agreement as to who owns the asset. So you see the number of problems that you yourself have created. The biggest mistake that people make is entering in. See, business is one, friendship is another. When you enter into business, make sure everything is in place formally. Do not take anyone's word for it. Don't go by good faith and all that. Make sure that all your documentation is in place. It's like buying a car. When you buy a car, you ensure that all the documents are in place. You ensure that everything is upfront. You ensure that everything is in order before you take possession of the car, right? Similarly, this is also an asset. Therefore, ensure your assets are protected. Okay, Unnikrishnan? Which regime is the most appropriate to protect a software, copyright or a patent? It depends on the manner of package of the software, actually. Both softwares can be protected under copyright and patent law. If it has to be protected under patent law, it has to be combined with a hardware. If it is a software standing by itself, then it is protected under copyright law. There are companies who manage to draft the specification in a particular way to ensure that the specification seems as like to the reader as that there is a hardware there and hence they're able to protect it under patent law. But again, it completely depends on what exactly you are using the software with, either with the hardware or without the hardware or standing by itself. So that would basically determine whether it's a copyright or a patent and what form of protection we need to take. Right. Even how service industries will make trademarks like any rental business. Evith, are you there? Can you speak up and unmute yourself and ask the question, please? Because there are a lot of sub questions that I would like to ask you. What you're trying to ask is sometimes I don't think it's coming clearly to me. So if you can ask, if you can just unmute yourself and ask, it would be much better, and I can answer you better.
Actually, I let me know how to protect a business model like some rental business model like that. Somebody not copied that business model.
So business models are slightly difficult to protect. Simple reason why, I mean, I can make a lot of changes in the business model. The end objective would still be the same. So let's say there's an Ola and there's an Uber and there's something called as Blue Smart. Blue Smart runs electric cabs. Ola runs electric cabs. And then you had Uber also running cabs. So they're all a cab aggregator service. It is all, how the services are split, how the trademarks are done. So it is very difficult to protect business models as such. I mean, business models just go out there. You can't protect it. If you want best way to protect it is by not doing the business only. The minute you put your business model out there and when you start monetizing it, people are going to take note. They're going to use the underlying idea, and then they're going to build up on that idea and they're going to add whole host of new things to it and then say, well, it is a new business model in itself. That's why you have so many fintech companies. That's why you have so many edtech companies. That's why you have so many cab aggregator companies. In the end, is always that they are exactly similar, right? There's no difference. What is different is obviously the brand attached to it, the services attached to it, the goodwill attached to it. So sometimes in certain countries, I like Uber better than I like Ola because Uber is better. Sometimes somebody may be able to argue saying, no, no, that is Ola's better. Completely up to, as far as I'm concerned, I've got good service from Uber. So I'm happy with the brand name Uber. So I would, when if I travel outside India also, I'll use Uber. Okay, even?
Okay.
Great. Even you had another question, right? Can you just touch upon that as well, please? I don't know whether I answered, I was able to answer you completely. Okay, he's gone on mute. Okay. Somebody wants to know, can sound and smell mark be registerable? Sound marks in India, yes. Smell marks, no, cannot be registerable as of now, because sound marks we can still graphically denote through the musical notations. So at the time of filing, we file the musical notations along with the particular sound which is uploaded as an MP3. Smell marks, impossible to graphically denote right now and not accepted in India as of today. Abhishek wants to know what registration need to institute trademark or copyright. You need to file an application at the copyright or the trademark office, depending on what it is. Unless I see what it is, Abhishek, I will not be able to kind of tell you further. I put my email somewhere, so you please feel free to get in touch with me if you require. I can maybe help you out when I take a look at what exactly you have at your disposal. And then tell you whether it's a trademark or a copyright, and if so, what are the procedures as to how to file it. Narendra, how to register a T idea? Narendra, are you here? If so, could you unmute yourself? Because again, I am not very clear about this question. Either I've not understood what TEA means, or I have understood wrongly what T means. So, Narendra, if you're there, just unmute yourself and come so that I can kind of ask you directly.
Hello, sir. My name is Narendra. As you
Hi,
know,
Narendra. Yeah. Hi, Narendra. Tell me.
I want my tea stall enhance. So tell me something about it and
You
how
want
to.
your, sorry, you want your tea stall?
We provide a herbal tea.
Okay.
Yes, and herbal smoke also. We are working on it.
Okay. So Narendra, you can possibly look to I mean I have not seen what you have with you. Maybe you can send me an email. I posted my email there, so you can send me an email later. But
Okay.
I believe that you could look at filing a trademark application. Your tea has a name, right? XYZ. XYZ Jobio. I don't know what your name is. Let's not go into public forums with it right now. But whatever it is, your tea has a name attached to it. Now, that particular name, that's how you're going to sell your tea. So if you take Tata Tea today, they're selling Tata Tea, we are Tata Tea, or we are Kanan Devan, or we are Red Label, or Taj Mahal, or Jobio. Okay. So your tea has a name, that would be a trademark. The tea may have a logo. Most companies I've seen today have a logo. Therefore, if that has a logo, then that logo could be protected as a trademark. I know that Taj Mahal has a logo, but I don't think that can be protected. Tata Tea has a logo of 2 tea leaves going this way. So that's something that can be protected. So that also can be protected under the law of trademarks. And if the logo is
Hello.
very artistic in nature, you could also look to file a copyright for it. So these are the various things that you could possibly look at. Also, if your packaging of your tea is very artistic in nature, we can open up the package, place it flat, and file a copyright for that also, if you require. Okay,
Sir, we have also a resort chain.
Sorry, you also have a
Resort chain. Resort.
you have a resort. Okay.
Yeah.
So same protections, Narendra. If you have a resort, your resort has a name. I go to your resort only because I've heard good things about it, right? On that name. So that particular name would be a trademark which you can possibly look to protect.
Okay. Thank you.
Okay. You can email me separately if I can maybe clear your doubts, as particularly to just what you're looking at. Okay.
Okay. Okay, sir. Thank you.
Okay. Okay. Someone's asking for an internship. Not exactly correct for it, but anyway, Sohail, the answer to your question is you can apply, yes. I don't know about the openings and vacancies because I don't look into it, the HR does. How do you apply? You can go to foxmodel.in. There's a form online. You can just fill it up. It goes to the HR. They allot it depending on their requirements and the requirements of the various departments and verticals which are there. Okay. And just to answer your question. Okay. Can a test mark be registered or not? Karishma, can you please elaborate on what a test mark is, please, for me and for maybe everybody else? Okay. Okay, I don't think.
Hello, sir.
Yeah, Karishma. Hi. Good evening. Tell me.
Sir, in one of the webinar, the sir told us there is one test mark for representative for a test mark. Graphically, it has been reported the graphic representative requirement was satisfied by using a written description for a test and indication that concern the test mark. Then my question is, test mark may be registered or not?
You're talking about a taste mark, a taste.
Yeah, taste mark.
The
That is
taste.
sound mark.
No. Hold on. You've written TEST. That's why you're talking about a taste of something, right?
Yeah.
Okay. Cannot be registered in India. It cannot be graphically represented. It's impossible. You could say maybe the recipe is graphically represented, but the objection always has been that if two people cook the same dish with the same recipe, the taste would absolutely vary. It is highly unlikely that the same taste would be there to the T. Therefore, it is almost impossible to register a taste mark. Maybe in the future, there might be technology which will help us with this. But as of now and till date, we cannot register a taste as a trademark. So again, it is like smell, a whole host of other things. It is difficult to do it as of today.
Thank you so much, sir.
Most welcome, Karishma. Oh no, don't apologize, Sohail. Perfectly okay. Yeah, Rohini. It's all-
Hi, sir.
Hi. Yeah, Rohini. Hi.
Hello.
Sorry.
Am I audible? So I have not been able to understand means the whole webinar, but I know the core. So I just wanted to know. It's just a curiosity. Like if some app or some product is there, so that can be patented or something like this happens. But what to do when I have created? It's not means it's a ideation stage, but I have tried to create a sort of system which is a social enterprise in which I am providing one service where, free, two are paid. By those two, the revenue will be just compensated to the free one so that I can pay the salary. So I just wanted to know, is there any way to get it just sort of patent or something, this system? Because someone has asked that, is it possible? So
Now, your patent of any system. So a patent is slightly more complex, Rohini, because firstly, we have to determine whether it is a subject matter of patent in the first place.
okay.
There are certain conditions within which a patent is granted or which is not granted. I mean, they're very strict about it. Okay. It has to be novel, it has to be non-obvious, a whole host of things are there. So the first thing that one will need to determine it is whether it is a subject matter of patent. So if you're approaching someone, I think that's the first thing you need to do is to approach someone and have them check whether it is patentable or not. Okay, only once you're able to do that, will you be able to take the next step. Because if it comes out in the negative that it is not patentable, then it ends there. But let's say it comes out in the positive, saying yes, it is possible to patent it. This is the way we can go about it. Then you go into, where all should I patent it? Costs attached to patent. What all do I need to do? So these are the other things that you can you will need to do at that
Okay.
particular stage. So at this stage, I think it's a little bit too premature, and I will not be able to comment on whether it is patentable or not, because there's a whole host of things
Okay.
which I really need to examine before we can determine or make that determination.
Okay. Okay. Thank you.
Hello, sir. Good evening.
Yeah. Hi, Vivek. Good evening.
Am I audible?
Yes.
Okay, okay. Sir, first of all, thanks a lot for sharing your experience and knowledge. It was a wonderful session, and I watched throughout the session you. So thank you so much, first of all. Secondly, my question is that can we search, suppose we want to have registered a trademark, can we search trademarks related to our product? Suppose for any product. Suppose if we want to register our trademark for a book cover, for example. So can we search the trademark related to this one? Is there any information source as like suppose if you want to search a patent, we can search the patent for Google patent after going to the site.
Yes.
Uh,
So,
so-
Vivek, there is, to answer your question. Okay. I've just posted a link on the chat box. Okay.
Okay, sir.
The
Okay.
link points to the trademark office's search facility. Okay. But
Okay.
see, how you look at a trademark and how I look at a trademark, or when I analyze a trademark, is completely different. You will look for an identical mark, or I will look for identical marks, deceptively similar mark. I will put it against the law which is there and then try to analyze it. Okay.
Yes.
But
Yes,
for
sir.
starters, to determine whether it is even registerable, at least identical mark, you can do that. Okay.
Okay, sir.
Determine whether there's
Yes.
an identical mark. Now, one step ahead of that, I would advise give it to your lawyer. Okay. It is like this. We cannot all be doctors. So if we are unwell, we should see a doctor and get the right medicine. If I have a fever, I know if I take a Crocin, my fever come ho jata hai. But if my fever doesn't go down in 3 days or 4 days and I'm still having high fever, I have to see a doctor. Taking
Yes,
2
sir.
Crocins may not help me. So similarly, the first stage you can do, but after that, do not. Ask your lawyer. So आपको, let's say you have 10 trademarks, आपको filter करना है कि यार इसमें 5
Yes.
कितना आएगा.
Yes, sir.
Identical
Yes.
marks, you can do it. It is possible. It is not rocket science. I think you already have some knowledge because you're talking about patents and Google patents. So I think you've already done something like this. So that resource will help you out.
Right.
The classifications also, yeah, I'm just,
Actually, sir, I am a teacher in engineering college. I'm assistant professor in electrical engineering department, also working in institute innovation cell. So
Okay.
that's why I have idea something about this. So.
Great. I've posted a second link, which is basically the classifications. There are 45 classes for your information, 1 to 34 goods, 35 to 45 for classes.
Yes, sir. Okay.
Services. Services.
Okay.
I've just posted a link which will help you with determining it. Okay.
Okay, sir.
So you can just use it. Hold on. Yes, I've posted the correct link. So there are a lot of office databases. Just look for CGD PTM. Okay, that would be the main heading. I will also try to post the classification headings, which would be easier than the earlier link that I posted. I don't know whether it'll open. You can just try it out. Okay.
Okay. Okay, sir. Thank you so much, sir. Thank you.
Most problems, sir. Arya wants to know when a company winds up and the trademarks are left unassigned, will it ownership work? Yes. So when a company winds up, it depends on whether they file for bankruptcy or not. If they file for bankruptcy and there are a bunch of people who are now going to be in charge of it, and the assets will devolve to them, and then depending on how the proceedings are being done and how the assets are being divided, it will accordingly be divided. So yes, there is a devolution of assets which happens. To who those devolution of assets happen will be determined by the tribunal at that particular time and date, Arya. But yes, this has happened in the past before and will consistently happen. Krishnan, again, you have a question. If a company has registered their trademarks in one class, can the same trademark be registered by another company for another class? Can the same trademark be registered by another? So yes. Well, actually, no. reason being that the classes are only administrative in effect. They're only meant for an administrative purpose. I mean, it's not a straight jacket thing, right? I'll give you an example. Let's say I'm a clothing manufacturer, nutrition, and I manufacture clothing, okay, under the brand name Matthews, or rather, let's just say MV, okay, for easy thing. Somebody starts manufacturing sunglasses saying MV. Now, clothing and sunglasses are cognate and allied classes. Therefore, the minute is published in the trademarks journal, I will file an opposition against that particular entity, because clothing and sunglasses could be sold also from the same place. So if you go to a shop like Shoppers Stop, you will find clothing on one side, you will find sunglasses also set there, belts also put there. So it is possible that there could be consumer confusion, right? The consumer could think that the sunglasses manufactured by you actually come from me. Okay, so there's a consumer confusion which can occur. Therefore, I can take action against another party if he is filed for an identical trademark, even though it is in a different class. But if the classes are also so far, like it is on a case-to-case basis, but 9 times out of 10, you will be able to take action against another party. And you should, because it's a clear dilution of your brand. Like if I'm not mistaken, there was a case in which Mercedes-Benz took action against an entity who started making undergarments. And unfortunately, Shushmita is also, Shushmita, actually you're wrong. They can try for another class. Yes, they can try, but whether they succeed or not is a completely different matter, because I won't let them succeed. Geographic coverage of a trademark. So if it's filed in India, your protection is very much territorially limited to India. You will have to go to various territories to file it. An easier way to do it is file in India. There's something known as the MATTED protocol, Unikrishnan. Therefore, we can use the MATTED protocol and extend your protection to various other countries, depending on if those countries are countries of interest to you. You will save a lot of costs as far as filing fee is concerned. So that helps you quite a bit. Official fees, pretty much the same, but you save a huge crux in under the professional fee heading. You don't have to go to separate attorneys in various countries. That is possible, but I mean, it has to be analyzed on a case-to-case basis. We don't ascribe that particular strategy for all trademarks. There are certain conditions which we speak to various clients to understand and explain what those conditions are before we kind of, push that strategy forward. During an assignment, assignee or assigner pays the fee. Example of company assignment. So in most cases, it is the assignee which will pay. See, it's an asset, right? I'm purchasing the asset. Now, once I've purchased the asset, I would like to have my name written there. So therefore, I'll be the one as an assignee who will make the payments to record it in my name. The agreement will say, listen, I've sold it to you. Now you go record it. It's like buying a car. I buy a car from you, Arya. Now I need to go get my RC corrected so that my name reflects and not your name. Therefore, I will have to go and take it up with the RTO to get it done. Exactly similar case. The assignee will have to go to the trademark office or go through his attorney to the trademark office and get it done, so that his name starts reflecting there. Unikrishnan, are you here? By the way, I think you are. Can you unmute yourself? No, you cannot register a trademark if it's registered in the US, but not in India. Simple reason being that the minute you go to publication stage, please be warned that people like me sit and, we have softwares and you go over the journal and we will oppose you. To file an opposition against a trademark in India, one does not need to have a mark which is pending or registered to initiate an opposition. Even if an applicant has not filed trademark in India, you can still oppose another entity. What you are proposing, Unikrishnan, would be clear out infringement. So please don't go into that. I would say if you are a startup, create something. There's so many ways in which one can be creative. Create a new word. Why copy from someone else, right? Sushmita, I've applied. Sorry. I applied a trademark DSA with full form. It accepted the new, but sometimes trademark is objection also criteria. For an objection, the criteria which is followed is under section 9 and 11 of the Trademarks Act. Basically on distinctiveness. If you can recall my slide, I had stated now have a mark which is distinctive, not descriptive in nature. So under section 9, if the trademark lacks distinctiveness or is descriptive in nature, objections are raised. If the trademark is identical to or deceptively similar to another trademark under section 11, again, objections are raised. Okay. Got you, Unikrishnan. Smart strategy. Follow up to the prior one. So 9,000 Arya is for a company. So company assigns to an individual. Will it fall? No. Arya, the request for an assignment is a completely different cost. The 9,000 or the 4,500 is the official fee for filing a trademark, not for an assignment. So please keep that in mind. You are talking about an assignment. An assignment is completely different. If you are assigning your trademark, then a request has to be filed for assignment. If an individual is filing a trademark, then it becomes 4,500. If a company is filing it, then it is 9,000. If an SME or an MSME is, sorry, startup or an MSME is filing it, it's against 4,500. I hope that answers your query. If I'm not mistaken, I think I've got the gist of it. Okay, you're welcome, Arya. Welcome, Vishnu.
Hi, Manju, Karthik here.
Yeah, hi,
It was a
Karthik.
wonderful session. Hope you can hear me.
Yes, Karthik, I can hear you. Thank you so much.
Thank you for the wonderful session. The participants have enjoyed understanding the complete started intellectual property. If required, if something in detail, probably we can plan another session coming months.
Sure. Happy to help you out. And in case any of the startups need any help, you can give my official email ID to them. I think you already have it, so you can just pass it on to them if they require it. Yeah.
So if anything comes by, we'll connect to you. We'll also connect later next week. Sometime you and me, probably
Sure. Sounds good.
in your office or in our office. Sometime we'll plan it out. Thank you for the wonderful session. Thank you for taking your time out, enriching your knowledge related to intellectual property for startup.
Thank you. Thank you so much, Karthik. Thank you for ISART to have me here. Thank you so much, all. Have a good evening.
Thank you. Have a nice. Thank you, participants. If anything is there, please reach out to Brijesh or me. We'll connect you to Matthews and his company for anything you require. They have 110 plus years of experience in the market of intellectual property or anything legal. They can help you out with respect to your startup or your trademark activities. Thank you everyone for holding to the session. Let's connect if anything is required.